As part of our work in the area of civil procedure and case management, we have developed a little bit of expertise in the area of electronic discovery. In fact, when the Institute first opened its doors, e-discovery was just emerging as a hot issue. The seminal case had just been handed down, and discussions were underway about rules revisions at the federal level. But there were still many lawyers and judges who had never encountered an e-discovery issue. I venture to say that is no longer the case. Electronic data defines us. We laugh at the extent to which our kids text or instant message each other, and then we each generate over 50 emails a day. Some of us, many more than that. What happens to all of that data in the context of a lawsuit? That's the topic of electronic or e-discovery. E-discovery has spawned a multi-billion-dollar cottage industry that didn't exist 10 years ago. And the sometimes mind-boggling cost associated with its use has created an environment of uncertainty and even fear in our nation's corporations, law firms, and courtrooms. Today, virtually all communication is electronic. I would venture to say that in another year or two, we won't even bother to make the distinction between discovery and e-discovery. All discovery will be e-discovery. Worldwide, about 100 billion emails and 5 billion instant messages are generated daily. The volume of electronically stored information doubles every 12 to 15 months. The CFO of a major corporation told us recently that if all the electronic transmissions they created in one day were reduced to paper, they would completely fill 5 50-story buildings. Years ago, a lawsuit involved a few files, or in the extraordinary case, a warehouse full of files. Now, lawsuits can implicate billions of electronic documents, and the challenge that we're going to be talking about today is in assuring that the data is managed in a way that honors, in a litigation context, the search for the truth without sinking the justice system in the process under the associated costs. We at the Institute hear from lawyers, litigants, judges around the nation who are struggling with this challenge and who report that the costs can be devastating and the process itself can be wholly subverted if the judge and the lawyers are not all knowledgeable and attentive. So, I'm going to introduce to you the panelists, and I'm going to ask them to start out by addressing how bad is it really? Is this all a bunch of fluff and overblown crying of wolf? Is it a ploy on somebody's part to try to change the way that things operate, or are we really in something of a Donnybrook? To address these questions, we have Greg Kerwin, who is seated in the middle, a litigation partner at the Denver office of Gibson Dunn. Greg has worked on complex litigation matters for 25 years. He has practiced with Gibson Dunn's Denver office his entire career since completing a clerkship with the 10th Circuit. He represents clients on cases in both state and federal court in Colorado and in many other jurisdictions. He has dealt with complicated e-discovery issues in many, many cases. He brings a unique hybrid perspective today. He'll tell you, I suspect, about a case that is currently bedeviling him, in which he represents the plaintiff, and he's up against an e-discovery issue of great proportion. Don McLaughlin is president and CEO of Falcon Discovery, a leader in in-house e-discovery consulting and services for corporate clients. Previously, he served as a consulting counsel to Quest, specializing in the areas of litigation cost containment, electronic discovery, and records retention. Don is a technology expert as well as a lawyer. Where others see questions, he has a tendency to see answers. Gary Seriani is the co-founder of Davis & Seriani. He has a national practice in complex commercial litigation, including representing both individual and institutional investors in large and frequently high-profile securities fraud cases across the country. He's listed in Best Lawyers in America and the Chambers USA, America's leading lawyers for businesses. Gary brings the plaintiff's counsel point of view to the discussion. This is a debate format, so I will serve as moderator and occasionally throw in my 2 cents. At the conclusion of the debate, we will open it up for questions from all of you. We would ask you to hold your questions until that point in time, and I promise you we will leave time for them. Okay, so Gary, how big of a deal is this? Is this really a problem, or is this just another manufactured bump in the road?
So I get to start the fire, right? Okay.
You get to light the fire.
Well, I'd like to, from a plaintiff's perspective, I'd like to maybe put it into a little bit different framework by stepping back 15 years and give you a hypothetical, and I want you to all assume that you're a judge and you have in front of you a case brought by a group of investors who purchased stock in an initial public offering. And they've sued the defendant, who is a national broker-dealer, was the underwriter, and they have served as part of that process a request for production of documents asking for the underwriter's files relating to this particular transaction. The case is now before you on a motion for protective order filed by the defendant. You look at the request for production, you see that it's limited to the specific documents relating to this transaction. So you look at the defense lawyer and you say, what's the problem? And what he or she tells you is this. They say, Judge, my client's been in business for 30 years, and during that time they have done probably 300 to 400 different underwritings. And as the SEC and the NASD requires, they have saved a copy of every single document that they either generated or that came into their office. And the way they saved that was they stacked it up in the back room. And when that back room got full, they went and they leased a warehouse. And when that warehouse got full, they moved everything into a nut bigger warehouse. And what we now have is a warehouse the size of a football field that is stacked wall to wall, floor to ceiling with stacks of paper. It's not indexed. There's no chronological rhyme or reason for the pileup. So, Judge, we know that every document the plaintiff wants is in there somewhere, but we don't know where it is. And it's going to cost us about $1 million to hire a group of people to go in and look for it. And so you need to tell the plaintiffs one of 2 things. Either they don't get the documents, or they got to come up with $1 million for us to go look. Now, my guess is if that argument would have been made to you 15 years ago, your response would have been something like, let me see if I understand this. Your client selected an archival system that makes it very expensive for them to retrieve their own documents. And you want me to visit the cost of that choice on the plaintiff. Fast forward 15 years. Much of what you're hearing now about retrieving archival documents is exactly the same argument. The only difference, it's now made in what I call this cyber geek speak, that when it's uttered, typically causes all of the eyes in the room to glaze over, including, in most cases, the judges. And then what happens is, not always, but a lot of judges will grab a hold of the one piece of the argument they can really get their arms around, which is that $1 million number, and they look at the plaintiff's lawyer and say, you don't really expect me to order this defendant to incur $1 million in cost to produce what are obviously relevant documents, are you? And so from the plaintiff's perspective, we go from making what is a very specific and relevant request to having requested something that's absolutely outrageous because of the way that the defendant has chosen to archive its documents. Our view is that that is a choice that the defendant makes. The technology exists now to archive those documents in a way they can be searched, and Donald addressed this more than me. And so we think that if a defendant makes a choice and he's allowed or it is allowed to do that, the disincentive that you're creating or the incentive you're creating for defendants to not produce documents is something that they're going to grab hold of. And the reason is because, and Greg and I have talked about this, but our fights now are primarily about emails. But there's not a lot of fight. I mean, some cases nobody will produce anything, but for the most part the fights are about emails. And the reason the fights are about emails is because plaintiffs love them. I mean, the story that we get from emails versus the story that we get after a careful deposition preparation is the difference between Hemingway and James Joyce. On the one hand, you get The Old Man and the Sea, which is very carefully crafted. On the other, you get Stream of Consciousness. And it's that stream of consciousness which truly generates, in our experience, smoking guns. It used to be that, you know, I look back on some 37 years of trying cases, and until recently, there weren't a lot of smoking guns. And the reason was because everybody did these things by telephone. There was no record. Well, now there is. And that's why these fights are a lot bigger than they used to be, is because most of us know that somewhere, both plaintiffs and defendants, somewhere in there is going to be a document that probably is smoking. Now, having said that, and kind of to set up Greg here, one of the things that I think that's happening with plaintiffs' lawyers is that we're starting to be a little more careful about what we ask for because we might get it. If I go in and convince a judge to order a defendant to produce 1 million documents, I walk out of that court saying, now what the hell do I do? Because I've just convinced a judge that there's 1 million documents out there that are reasonably calculated to lead to the discovery of admissible evidence. If I've done that, don't I have an ethical obligation in order to diligently represent my client to look at them all? If I haven't, have I committed malpractice? So I think it's slow, but I think you're going to see, as it always is slow, you're going to see some cooperation start to develop, not because of any feeling that the defendants are being any more forthcoming than they've ever been, but because I got to be careful what I ask for, because if I get it, then I've got a real problem. I think one of the keys is to do two things. One is to stage discovery. If you've got an ocean of data out there, I think there are ways that you can start by penetrating 5 feet below the surface. And then depending upon what you find, you can go deeper. You can do things like talk about summaries. You know, part of the problem is we have this old, please produce all documents that discuss, concern, relate to evidence, and so we cover the waterfront. We're going to need to be a lot more precise in the documents that we request. Because of that, be careful what you ask for, concern. The other thing that's absolutely essential in my experience, and I'd be curious to hear what Greg said, is judges have to be actively involved. If the judges back up and basically say, I don't understand this, I'm not going to get into it to the level where I'm going to tell you what the search terms are going to be, or what metrics we're going to use, or what protocols we're going to use if you can't agree, then I think you're asking for the case to spin out of control. So there's a combination of both that I think needs to be done. Is it a huge problem? Yeah, it is, but it's a problem from a number of different perspectives, not just from the defendants. When discovery has turned into the tail that wags the dog, and we have clients that walk into our office with a $150,000 case, and we have to tell them that that's uneconomic, then something's wrong with the system. Because those people should have every bit as much access to the courts as the corporations who can afford to spend the $1 million to get the discovery they need to produce their case. So yes, it's a problem. I don't buy the dollars that we hear thrown around. They may be true, but it seems to me that you really need to think about the incentives, particularly when you're talking about defendants or talking about parties that are engaged in dealing with the public in ways that require that they be upfront and forward. Trucking companies, drug companies, underwriters. There's a societal interest in ensuring that those people don't engage in a process that allows them to hide what they're doing. And if you allow them to use the e-discovery by throwing out big numbers, which are scary numbers, millions of dollars here, millions of dollars there, I think you're going to hear some of that later. I think you need to be careful that that dollar figure doesn't become the tail that wags the dog.
So Greg, do you agree? Is this just a question of evolving technology and forcing defendants to think differently about the way that they archive their own materials? Is that the issue?
No. First, let me say thank you for coming, and I am truly intimidated by the experience and knowledge of this audience, and hope I can add a few ideas, but I hope we can tap into the ideas of the many experienced people here. But to address Becky's question, how bad is it? It is really, really bad, and it threatens to affect litigation as we know it. I was reading something within the past month where people were studying why there's a downturn in litigation right now, and some general counsels are saying e-discovery is just too expensive. We can't litigate our disputes. Now, maybe that's a good thing. Maybe it's better to have more people working out settlements, but if our dispute resolution mechanism won't work, if it grinds to a halt because of the expense here, something is really broken. And I actually agree with Gary's recommendations, and I'll circle back to those, but I think many of the judges that I deal with on this are like ostriches with their heads in the sand, wishing this would go away, and it's not going to go away. I guess a variation of that is the new Sedona Cooperation Proclamation that some of you may have seen, where it essentially says, why can't everyone just be nice to each other? And maybe the system can encourage that, and maybe it can. I hope it can change. But I think judges are going to have to be far, far more involved to make that happen. It's not going to happen with lawyers who are trained as adversaries the way we all are, just working things out. I was interested that Gary used the example of an underwriting firm. I was working closely with the head of litigation at a major Wall Street underwriting firm. They're still around. And I was talking with him after the litigation about what he enjoyed most and least about his job. Number one that terrified him about his job is electronic discovery and retention. And this was not Morgan Stanley, but he had watched Morgan Stanley down in Florida come under potential criminal investigation because in-house lawyers had failed to find emails on a timely basis. There were some archive tapes in somebody's closet that didn't get timely disclosed. There were trial sanctions down there. And so for in-house lawyers, and I think this is a relatively common thing, meeting your obligations, whatever they are, because they're very amorphous, to retain relevant information is terrifying. And it is only one step removed for outside counsel like me to advise clients about what do I need to retain and when do I need to retain it. And courts sometimes make it seem like it's clear-cut. Well, of course you should keep everything related to the subject of the lawsuit from the moment you know there will be litigation. Easy to state, but what is everything related to the lawsuit? Because things go out in concentric circles, as we're used to with discovery, and things that you never anticipate would be relevant to the litigation may pop up. I agree with Gary very much about emails, and as we were preparing for this, one of the things we were doing is contrasting what it was like 15 years ago when we weren't as conscious of electronic materials. They were still out there, but not as prominent. And emails are just amazing to me, and every time I hear about a major case now, it seems to focus on emails. There was some prosecution announced in Washington just a week or two ago, and of course, at the heart of it is some incriminating emails. And for both plaintiffs and defendants, they're magic or they're devastating because they're the closest thing we have to a video camera taking pictures of what's going on. They catch people at their most unguarded moments and maybe foolish moments. And so, of course, people are interested in them, and that's not going to go away. I don't text, but I see people texting all the time. Our society isn't going to change. We're all somehow addicted to this. And so email management, I think, is the greatest problem. And as Becky said at the beginning in her introduction, it's the volume that is the problem. And I wanted to get some numbers in front of you quickly. I won't walk you through the details, but in the packet in your red folder, I put together a memo with help from one of my colleagues, Casey Lewis, who is here, who has been living with me this hell of a case on discovery, living hell, sorry, on discovery. And I just wanted to get some numbers in front of you to see how email and e-discovery costs can spin out of control in a case that might seem where they ought to be reasonable. And Becky pointed out that we're representing the plaintiffs. That's true, but it's a business dispute, and so there are strong interests both ways. A lot of people think symmetrical cases where you have big company versus big company, there should be more incentive for people to be reasonable because what goes around comes around. It hasn't worked out that way for us. I put some take-home messages on the back, but I wanted to get the cost number in front of you. We couldn't agree on the number of email custodians whose emails would be produced. And the judge had to decide and set it at 30 for our client. And we breathed a sigh of relief thinking, wow, only 30. This is for a company with over 10,000 employees. And 30 email custodians, the production of their emails with lawyer review for responsiveness and privilege and all the electronic processing that Don is so familiar with cost over $3 million. And that's just to produce them. The whole next step will be to search them and to find out which ones really matter. And one of the things that shocked me as we went through this process is we've produced now almost 10 million pages of electronic materials for our client. And the idea of reviewing every one of those pages to compare them with over 100 document requests and say this is responsive and this is not, it's almost impossible. So you presume that they're responsive. You don't have any choice because you can't withhold things that otherwise might be responsive. Completely changes the dynamic. It made me wonder whether the days of discovery requests that we're all trained to do about produce all documents relating to X, Y, or Z subject, why bother? Why not say we want emails for 5 custodians that have the following 6 words, preferably with proximity connectors, and make it all mechanical, because that's, in essence, in a big case, how we're searching for responsive materials anyway. But in our case, the defendants had to do the same kind of thing. It's an antitrust case, not a securities case, doesn't involve underwriters. But now we are dealing with the staggering cost of understanding what's there. And we regularly find gems, emails, very damaging emails, and we're just beginning to tap the surface. A sad comment here, we've had to go offshore, and we have lawyers in Hyderabad, India, helping us evaluate these really talented people because our litigation system is so expensive. It doesn't make sense in the context of this case to use US lawyers for that kind of work, and yet we still hit more than $3 million in cost. And I guess Don, he and I were talking before this program, I guess we're kind of average for a big case. But imagine the dynamic when you're spending that much just to bring relevant information to light and how that changes the whole process of whether to bring litigation, and if so, how to get it resolved, and whether people will use the mere cost of it to discourage the litigation of the merits, to administer justice, which is what attracted us all to this profession. Let me just touch on a few of the solutions that Gary mentioned. Oh, and one more comment. It's not about opening the warehouse. If I'm a plaintiff and the defendant opens the warehouse to me and it's electronic, it's all full-text searchable. I don't mind. When I learned to practice 15 years ago and we heard people talking about opening the warehouse to paper documents, yes, that was intimidating because we had to go through it manually. Opening the warehouse now is no big deal for a plaintiff. And the action is not about what's reasonably accessible and how companies archive it. What I'm focused on and what these costs are about is stuff that is on active servers readily available, and it is still terribly costly to have to deal with. Yes, there are issues about companies that archive old materials and whether they should have to go to the cost of that, and complicated decisions for judges to make about that. But that's not where the action is now, and that's why, with all respect to my friend Gary, the issue is not about how companies make decisions on their own to store things in an inaccessible way. The costs are immense just with what's readily available. On the solutions, because that really ought to be what we're about, staging discovery is wonderful, and when you can find a reasonable adversary who's willing to consider it, it's great. I haven't found many of those adversaries, and that's one area where judges need to get involved, and a lot of the groups that recommend this advocate that. Don't do all the custodians at once. Do a few. Test out your search terms. See how broad they need to be. Gary talks about summaries, and I think that could be incredibly helpful too. But my main message, and I know we have some judges here, is judges need to get involved. You can't go hide out and pretend this isn't an issue. You need to be proactive in getting these litigants together and resolve the issues when they can't resolve them, and don't let one side use the cost as a club to avoid the issue of what's the just result and instead pile on the costs. And yet, in my experience, so many judges are not approaching it that way. And the last comment I would make, and maybe this is a segue to Don, is it's not that complicated to understand what's happening. Companies store electronic information. There are services that go out and harvest that. You typically, on emails, figure out numbers of custodians. You work out search terms. You filter the data. And then from those emails that are left after filtering, you decide what to produce that's relevant and not privileged. It's not that complicated. And there are options along the way that make it very expensive or less expensive. And that's where judges can help and impose reason on this process, because it has become a battleground that's just going to get worse and worse and worse. So I would urge you to look at some of the lessons learned in this case study. We kept it anonymous, but it's based on real facts, and I hope you'll find it terrifying.
And not a Colorado case, right, Greg?
And it is not a Colorado case.
Right. Okay, Don, the floor is yours. Talk to us about how you see this problem, what some of the solutions are, and also what some of the costs are. What are some of the rule of thumb numbers that companies work with?
I think dovetailing with Greg's comments about the case study that he's presented in the materials, which I think is very, very illustrative, it puts this issue in context, I think, because while I agree it's not complicated, the existing paradigm through which discovery was handled, I think, simply is broken. And by that I mean litigation treated as a one-off contingency that could be dealt with by corporate clients on a one-off basis is I think, a recipe for some of the disasters that we've talked about. Well, what's the disaster? Is this really a problem? In the context, I'll present this along three axes: volume, complexity, and cost. In terms of volume, historically, as has been alluded to, discovery involved talking to custodians about where their documents were. They're pointing you to file folders and cabinets. Perhaps there's a number of boxes that need to be gone through in a case. A medium-sized case, even a large case, several hundred boxes. Today, the metrics bear out the following in terms of volume. Of material that's actually searched and reviewed after it's been searched, it's not uncommon for each custodian to have in the range of 50,000 items to review. That's staggering. If you take that again and look at it the historical perspective, where if there were a couple of boxes per custodian, you're looking at today 200 boxes per custodian, per person. So it's on a different order of magnitude. And why is this? Well, as we've talked about, there's just so much more out there. Electronic communication is so much more rapid, and the volume is extensive. Take one day in the life of a finance person. There are versions of reports that are updated daily. These spreadsheets, you've got September 12th, September 13th, September 14th. I think that becomes clear. In terms of complexity, what's the problem with complexity? Is it really that bad? A simple example. An Excel spreadsheet becomes very important. Outside counsel has a printout of the spreadsheet, and it turns out that the formulas in the spreadsheet and the metadata associated with that spreadsheet, when was it last saved, who saved it, is important. Outside counsel has the printed out spreadsheet. The question becomes, the other side is demanding, the court has required that we produce that either natively or as an image with metadata. The problem then becomes, how do you get to the original file and produce it with the metadata? So it presents a challenge from that perspective. And I think that was noted by the Rules Subcommittee in their comments when they endorsed the revisions to the Federal Rules of Civil Procedure dealing with electronic discovery. Volume and complexity, two significant factors. And then cost. Greg has this case study, which I think hits this issue right on the head. At the end of the day, basically for processing this electronic data for 30 custodians, right, which you'd consider maybe a small to medium-sized case, and then reviewing it with offshore reviewers at $25 an hour, $3 million, $100,000 per custodian. Not an uncommon figure. Oracle and SAP are in a big fight in the Northern District of California. And Magistrate Judge Laporte has been dealing with lots of discovery issues in that case. And SAP submitted a very detailed affidavit, Jones Day did, detailing the costs. And those costs were roughly $100,000 per custodian, using contract attorneys for review. So I think that whether it's this cataclysmic problem or not, it certainly changes, even in my very, very, very brief experience practicing litigation, the paper-based world to now a digital era. And some of the things that Gary mentioned in terms of what to do and what can be done. Well, I think there's a misperception that that if it can be stored and searched effectively, why is it so difficult? And the reason that I think that doesn't apply, and I talk sometimes as much with IT and forensics people as much as I do lawyers, there is no easy button, and they like to show me that very vividly, is because there are inherent complexities, as we've talked about, with the types of files that are involved. Near duplicate files that just creates, again, this volume problem. So I think for the client, understanding this dynamic is important, because one of the ways that we help clients attack this is really from the inside out. And that's to say, are you going to get sued? Yes, you're going to get sued. And so how can you best prepare for that reality such that you're not dealing with this on a one-off basis, where in each and every case you need to have outside counsel understand your information technology infrastructure. And unfortunately, outside counsel is put in this very difficult position of historically, and rightly so, being viewed and tasked with being the expert and being proficient in both the procedural and substantive aspects of law and legal discovery. When this is a totally new world, right, a new landscape, how possibly could outside counsel understand the intricacies of a client's information technology infrastructure and the technology that can be used to identify, collect, and cull that material efficiently? So I think for clients, there's a real learning lesson, and there's real incentive to understand this from the inside out, from the client's perspective, and certainly use technology to address this problem by looking at what exists in the company, leveraging that, and then getting down to brass tacks in terms of, well, what does that translate into? Gary alluded to staged discovery, and Greg's perspective, which I understand, is, well, that assumes that you've got parties that are willing to go that route. Well, if you did that prior to that stage, and the client actually had some capability to do assessment and analysis early on, that does two things. One, for the client, it puts them in a better position to understand what the litigation risk is, the cost benefit, and then second, puts them in a much better position to be informed both with their adversary and with the court. I think many of the problems that I read about in cases stem from a lack of information and sort of stumbling around in the dark, not knowing A, what it's going to cost, and B, what's really at issue, which custodians matter, and how are you going to get to the information that may be very, very relevant. And on that point, the last thing I'll say there is, it's striking to me how, and I'm not pointing fingers because I was susceptible to it in practice as well, the failure to bring the people that are involved in the case into the fold. the engineers, the marketing folks, to understand how do they refer to things, for example, for search terms, and getting their involvement early on. So those are some of the things that come to mind from my perspective.
Okay, so there's some common themes here, and I'm going to bat it back to members of the panel, but let me pull some things out for you that are emerging. First of all, it's about access. We used to talk about access to justice, and we would think about legal services, and we would think about the indigent. Now we talk about access to justice, and we think about ourselves. How many of us could afford to file or to defend a lawsuit on our own behalves? How many of us could afford to litigate it all the way through to conclusion and take it to trial? It isn't now just trials that are going away. It is, as Greg says, litigation in general. And I don't think that's a good thing. I don't think we ever really had a litigation explosion, but certainly the courts need to be open for business for people who need to resolve their disputes in the manner in which our system of government contemplates. So it's about access. We have freighted the system with so much cost that we have impeded access. The solutions to that. Gary is saying part of it is in getting defendants educated, or companies, not just defendants, companies educated about how they need to keep their own records. Greg is saying that's not really it at all, and I think Don is sort of somewhere in between. Gary, go back to that point. He wrote me a note, by the way, up here that says rebuttal with, with a big question mark. So well, I'll give you the opportunity for rebuttal.
You know, I'm a plaintiff's lawyer. What do you expect? The thing is that, yeah, there's a problem, but there's also a whole lot of crying wolf here. And let me give you a couple of examples. We heard from Greg about how expensive this case is. He didn't tell us how much is involved. Is it a $100 million case, a $200 million case? My guess is involves a whole lot of money, otherwise we wouldn't be at this stage, okay? So maybe $3 million in the context of that case is not all that significant. The other thing is that I don't think there's any judge around that's going to do what that Florida judge did in that case, which is basically enter default judgment, based upon the fact that there were just a couple of magnetic tapes in somebody's closet that didn't get found. So I think there's still a lot of a wolf here. Another example, well, gee, we have this tremendous volume because now we have these spreadsheets that are made on September 12th, September 13th, and September 14th. Well, we had those before. They were just on paper instead of electronic. What's the difference? There's a lot. This is where we get into that cyber geek speak that I was talking about before. You throw up this pseudo-scientific argument that doesn't really address the fact that nothing's changed except the media, but you want to use the change in the media as an excuse for not producing what you would have produced had it been in documents. I mean, I spent 3 weeks in a warehouse in Memphis when they brought me boxes of documents with a forklift, okay? I'm willing to go through the, as he says, through the, maybe one of the problems here, well, one other quick comment, metadata, okay? That's another big bugaboo, okay? I don't care about metadata until I get a specific document that is significant enough that I want to find out when it was created, when it was modified, where it came from. I don't need metadata for every single document they produce. When I review a document on CD, I don't look at the metadata. I look at the document to find out whether it's anything that has anything to do with the case. If it's significant, then I care about metadata. So stage it. All right? When you produce it, you don't need the metadata, but you have the right to come back with any specific document and get the metadata if it becomes significant. And then one final thing, which is just struck me as I was sitting up here. You know, the real problem in a lot of this is not so much the generation, but the review. And what is the purpose of the review? It's for privilege. All right? Maybe we need to address that sacred cow in some fashion. It's been touched on. There's been this little bitty nibble at it with the clawback provisions, but maybe we need to hit it a lot harder. Maybe we just flat need to say that you can't withhold documents on the basis of privilege, but that any document that's going to be used in a trial can can be addressed and can be clawed back, okay? That solves your review problem. Now, I know there are a lot of, it's kind of interesting because I'm not sure who has the more objections to that, whether it's the lawyers who don't want the advice they're giving to see the light of day, or whether it's because the defendants really don't want plaintiff's lawyers to get that. But if you address that issue in some way so that you don't have people saying, I've got to review 1 million documents for privilege, a lot of this problem goes away.
Greg, Gary raised, sort of on the offense, the question of proportionality by suggesting that you didn't mention what's at issue in the case to which you referred. How does proportionality fit into this, and who's in charge of assuring that the discovery costs of a particular case are proportional to the issues in that case?
Well, first, our case is a big case, several hundred million at issue. I wanted you to see the cost of just producing 30 custodians on a broad array of topics in what is admittedly a big case. Proportionality has to be up to the judge if the parties don't work it out. And in the asymmetrical case, small plaintiff versus big defendant, the parties don't usually work it out. And so someone has to get involved. Gary and I were brainstorming about where the world might be 15 years from now, and maybe with technology and everything, maybe vast quantities of information but readily available, maybe people will be simply comfortable plugging into the adversary's computer system, running their searches, and taking what they want, and no one needs to search it. And I agree with Gary that the major cost is review, although it's not just privilege, it's responsiveness too, because some of us are old-fashioned and we think we ought to produce the documents that relate to the dispute instead of producing everything, and occasionally get accused of piling on all kinds of irrelevant stuff to hide things, which is not the case. But there are plenty of plaintiffs out there who would say, if you don't make distinctions to determine what's relevant, you're not honoring the rules. But on privilege, I mean, the government went down this path 5 or 6 years ago in demanding of criminal people being investigated that they turn over all their privileged material. And there was a huge pushback, and the government, the DOJ, pulled back from their demand to disclose privileged information. I don't think our corporate culture and our litigation culture is ready to ignore privilege. I think most of us in the room understand why it's important for clients to be able to seek counsel and why it's damaging to have adversaries see that advice, even if it gets clawed back. You know, people read it because they have to find out that it's privileged and to turn it back. So the idea of simply giving up on privileged materials is not likely. There's certainly technical things you can do to search for privilege, though. You can search for names of lawyers, key terms that would show up, and there are a lot of things you can do to try to filter that. And so maybe a technology solution 15 years from now will be better. But right now, the cost is very, very high, and that's why the cost needs to be proportional to the amount in dispute. And in smaller and medium-sized cases, we need some workable system, and we need to have the participants in the process sensitive to the cost and ways to reduce the cost.
So Don, where are we going with all of this? What's it going to look like in 5 years? What would this panel be like 5 years from now?
Well, I think that the trend is certainly headed in the direction of a much more scientific, rigorous approach to the search and retrieval exercise, because at the end of the day, that's a big driver here. There are metrics out there. IDC Research several years ago came up with a figure: 80 to 90% of materials gathered in connection with litigation are not relevant. So that obviously inverse 10 to 20% is relevant, and that's certainly consistent with our experience. The delta right between those two is getting down to the 10 or 20% that is actually responsive. Well, it takes currently quite an effort to get to that 10 to 20%, and I certainly hear what Greg is saying, that part of the exercise for the responding party is to actually provide materials that are responsive to the issues in dispute, as opposed to, you know, Don, Steve, and Sue were involved, so let's just collect all their stuff and turn it over to plaintiffs, kind of what Gary is alluding to. That parties have been down that path, And there are cases out there where defendants have done just that in response to plaintiffs' requests. Taken a couple of DVDs, loaded all the material natively, right? PSD files, directory structures, given it over to the plaintiffs as plaintiffs requested, and then plaintiffs cry wolf. Because then they have DVDs that they need to bring to a third party, and they get a bill for $55,000 to make heads or tails of these electronic items and to be able to make use of them. So I think that that this search and retrieval process is under close scrutiny, certainly in some jurisdictions, because of two principal reasons. One is because it can obviously make a huge difference in cost, and parties, I think, are figuring that out, and there's a real battle about search terms. The other thing is, with respect to privilege, is that there is a case, the Victor Stanley case, where searches were run to run a privilege filter so that all the documents would not need to be reviewed for privilege prior to production. Unfortunately, in that case, and there are others like it, the process of search and how the filters were applied could not be replicated sufficiently to establish what steps the defendant took to prevent the inadvertent production. And so here's another example where the search process itself is under a microscope. And part and parcel of this search and retrieval process, certainly there's a process around it. What's that process? What search terms did you run? What were the search results? How did you modify those search terms? Why were they modified? Is important, that process itself. But then the technology, I think, is increasingly going to become an issue. And 5 years from now, I think even today, and where we're headed, is that technology is getting better and better. It's amazing what these engineers are able to do in terms of the algorithms embedded in this technology that can find related material that may not even have the search terms in it. So you ran search terms, but the software brings back documents that don't have the search terms in it. But when you review the document, sure enough, it is a relevant document. And then likewise, technology that mimics human decision making. That's sort of a fancy way, and it's in the artificial intelligence speak, I think, quite often. It's really a fancy way of saying, find more like this. So if I'm the expert on this one particular issue in this case, I'm going to sit down and I'm going to review a statistically valid sample set of documents based on the whole corpus of documents. I'm going to look at those documents. I'm going to make subjective judgments, and then the software is going to essentially learn and mimic the decisions that I made about those documents. I think looking ahead, there's real promise in what the technology can do. Again, with the caveat that it's still not, I don't think it's going to be an easy button. There's still going to be a lot of issues to work through.